This is Brent. Brent Allen Winters, commonlawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up a racket all night long. And talk about our Constitution of the United States. That's slice, yes, 147. Question. Stansbury's Catechism on the Constitution of the United States. May slaves be imported, that is, brought into the United States? Answer, no. Whoever engages in the slave trade is a pirate. Pirate. 148. Question. May slaves be held, that is, owned and made to work by citizens of the United States? Now, back when this was written in 1828, the answer is yes, because at that time, slavery existed in some of the United States. Remember, slavery existed in all of the states at one time. All of them that I know of, north and south. Then the northern states slowly began to say no because it wasn't economically useful. In the South, most of the slaves were owned by large plantations. There were unknown numbers, thousands of people that had one or two slaves. Remember Tom Sawyer and Huckleberry Finn. Those stories written about a boy that lived in a little village called Florida, which is nearby Hannibal, Missouri, on the Mississippi River between Illinois and Missouri, actually in northern Missouri, a slave state. And Miss Watson, the widow Douglas, not Miss Watson, the widow Douglas, a widow woman, had a slave and his name was Jim. Remember Jim? And Huckleberry and Jim were pretty good friends. And Huckleberry then tried to help Jim get south on the Mississippi River at Cairo and turn north up the Ohio and get into free territory. He was a runaway slave. But there are a lot of people that just owned one or two, and a lot of small cotton producers, very small. But it became the economic backbone because of the plantation owners. The plantation owners were running a Roman system of agriculture, which means it was founded on slavery. Well, that didn't go well in the northern states. Were there slaves in the northern states? Yes, even after the slavery was done away with. There were those that owned land on both sides of the Ohio River, from Kentucky into Ohio, Indiana, and Illinois, that owned slaves and farmed on both sides of the river and took their slaves back and forth. That was common practice. Some famous court cases arose after the Fugitive Slave Act concerning those kinds of cases. And I have the complete narrative of one of them in the book, Excellence of the Common Law, about a slave owner in Bourbon County, Kentucky, that came over every year and kept a slave in Illinois as proprietor of his property there, his farm there, and then had that man's wife, that proprietor's wife, a slave woman, and her 4 children stayed with him and went back and forth when it came time to plant and harvest and all that. But eventually that went to the courts for a good reason. You can read about it in Excellence of the Common Law. The slave case was a habeas corpus case. If a slave escapes from one state into another, back at that time, may the state into which they flee, the slave, set them at liberty. Question 150. Now, this is what the Marston slave case was about that I told you about, the fellow in Bourbon County, Kentucky, that was going back and forth across the river and farming farms on both sides and taking his slaves back and forth. One of his slaves, the wife and her 4 children, her name was Sally Bryant and his name was Bryant, It was kind of a messy deal. Because he had this slave in Illinois, in southern Illinois, the proprietor of his farm there, then he had his wife that stayed with him down in Bourbon County, Kentucky, and her 4 children, which was the 4 children of the proprietor of the slave in Illinois, and he was a slave in Illinois. But he also had a Bridget, and that's what people back then called an Irish housekeeper. He had a Bridget. Now, it seems probable when I read about the case that he probably had a lot of stuff going on with Bridget. His name was Marston, and he had a lot of stuff going on with Bridget. He took Bridget back and forth. Well, when Bridget got up, he took her up to Illinois to put out the crop in the spring, and he'd stay there with Mary and her 4 children, up to be with her husband, who was the proprietor up there. And he'd stay and tend the crop, cultivate it, and then harvest it. And the soil was black up there, and he grew crops up there. He didn't do as well down in Kentucky, and vice versa. He'd grow hemp. Yeah, that's the Mary G. Warner plant. Down that was bigger than cotton in Kentucky. They had tobacco, but they also had hemp. Good for making rope. Very, very high demand for hemp. High dollar crop. But up in Illinois, he raised other things. Corn, for instance, was big, alfalfa. The dirt was blacker, very black. Matter of fact, it was coal black and very rich. Well, he got up there and he brought this Bridget with him, this Irish housekeeper, who it looks to me like he was carrying on with. Well, anyway, she saw herself as his concubine of sorts, probably. Well, she got into a spat with the slave woman that he'd brought up with him and had 4 children, and she was wife to the slave that was the proprietor of the property in Illinois. Well, they got in a spat about the kitchen. I mean, who's in charge, right? You got 2 women in the kitchen, that doesn't work well. Somebody has to be in charge. Well, it didn't work that way because Bridget thought she ought to be in charge. She's the white woman, even though she was Irish and actually worth less on the market of servants and employees, worth less than the slave. That was true back in them days. But she got in a fight with Mary Bryant, the slave woman, and said, look, you mouth off to me one more time, and I got a lot of influence with old Marston, your master. I'll have him sell you down the river to the big plantation owners, and you'll be treated like an animal. See, the slaves in the deep South often were treated like animals. They were livestock. But in the other states, and to varying degrees, they were more like family. They were part of the household. It resembled more the slavery of the Bible, of the Old Testament. You had your servants, and you had your children and grandchildren and extended family, but that comprised your whole household. And if you were the patriarch in those days, you were responsible for your slave. And by the way, if you had no children, like Abraham, you remember the story from the Old Testament, your chief slave inherited all your property. That was the custom if you had no children. He was that close to the family. We read about that also when I was reading to you about Jack Henson's private war. It was in Kentucky, just south of Metropolis, Illinois, land between the rivers, the Cumberland and the Tennessee, where they come into the Ohio there. And he had, somewhere between a half dozen and a dozen slaves, but they were part of his family. And when he thought he was in danger, he moved his wife, who, by the way, was a cousin to Jesse and Frank James, he moved them over to Missouri, and he deeded his farm called Boiling Springs or Bubbling Springs Farm. He deeded the farm over to his slaves. They were that close. It's a culture that's not talked about now, but it was an important part of the culture of the more of the border states, Missouri, Kentucky, Tennessee, Arkansas, and in other places too, but it was a part of the culture that the slave was part of the household and part of the family, to put it that way. And they viewed them very differently. Well, he got in a fight. Mary and her children got scared and thought, well, maybe Bridget does have a powerful influence with the master, and they got rabbit in their blood over that, and they up and hightailed it to I've told you this story before. It's in the book, Excellence of the Common Law, because it's a habeas corpus case. They were eventually captured by the sheriff, put in jail to await judgment of the court on a habeas corpus. And they argued the free soil doctrine. Abe Lincoln was involved. Abe Lincoln represented the Marston, the slaveholder. Oddly, he lost the case. But what we're getting into here is, it was important back then. It was the thing that eventually tore the states apart and resulted in the slaughter of almost 700,000 Americans during that horrible war between the Confederacy and the Union troops. Horrible and unnecessary, I might add. Utterly unnecessary. Utterly. And it didn't do what people said it would do. It didn't. It did not free the slaves. If they escape from one state to another into which they flee, may that state set them at liberty? No, that's under the fugitive slave principle. Suppose any American citizen is seized, question, suppose any American citizen is seized, that means grabbed, arrested, and put in prison. May he be kept there as long as those who seized him think fit. May he be kept there? Answer, no. He may, or somebody on his behalf may, petition the court, the local court, to issue a writ of habeas corpus. Habeas corpus. Question 151, what is that? It is a command from a court. A writ of habeas corpus is a command from a court by which the jailer, commanding the jailer, whoever the jailer is, whoever's holding somebody within a confined boundary, forcing the jailer to bring the prisoner before the judge and prove that the jailing of the prisoner is lawful. And if it is not lawful, the court is to set him at liberty on the spot. On the spot. No, none of this, well, you got to send him back to jail so we can process him out. No, it's too late for that. On the spot. Called a writ of habeas corpus. Question, must this command from the court, the writ, to bring the body of the prisoner before the court, must this command be given whenever it's applied for? Yes. The writ of habeas corpus is not, you asked the court for a writ of habeas corpus. That means you ask the court to issue a written command, that's what a writ is, to send to whoever the jailer is and order him to bring the body of the prisoner before the court and prove that the jailing is lawful. And if he can't do it, the court, by law, is to set him at freedom immediately. This is near and dear to my heart. This subject is precious. Question 153. When may this right of having a writ of habeas corpus, which belongs by the Constitution to every man and woman, may it be suspended? May it be ignored? Answer, yes, but only in cases of rebellion, invasion of the country by an enemy, when the public danger is so great as to require persons to be kept in prison who might otherwise be set at liberty. As soon as this extreme danger is past, the right of habeas corpus must be immediately restored. We're going to stop there today. Make mention of a couple of things. If you don't go to the words and find out what they mean, you're missing something. Habeas corpus. What is it? Those Latin words again. Fancy Latin words. What does it mean? Those Latin words means we have the body. We have the body. Well, that's short for We have the body, let's get it before the court. Habeas corpus, bring the carcass of the person you've jailed before the court. No, you can't come into court and prove that the jailing is lawful without him here. No, he's got to be here. Why? Because if the jailing isn't lawful, we think liberty is so important, we're going to turn him loose on the spot. We're not going to delay 15 minutes, 10 minutes, 2 hours to process him out. No, right now. He's in front of the judge. The judge says, you're free to go if he believes the jailing is unlawful. Habeas corpus. How important is that? Oh, there's no limit to saying how worthwhile and important it is to liberty, the most fundamental kind of liberty there is, my friends. If you've experienced it, you'll discover it. The most fundamental kind of liberty is liberty of bodily locomotion, to go where you want to go when the urge hits you. That's called freedom. If you don't have that freedom, as a matter of life down here on earth, well, you don't have much. Freedom to get up and go where you want to go. If you're in prison, did you know if you're in prison, in a lot of prisons, if you're in a room, the doors automatically lock and they automatically unlock on a clock every hour, every half hour, whatever. And you just have to wait until they let you go to another room or another place. And you certainly can't leave the boundary of the prison. You're imprisoned. That's called imprisonment. And false imprisonment is so atrocious to our common law tradition that we do everything we can to avoid it. And we have. I don't think we're doing it now. Habeas corpus is to alleviate any false imprisonment and to do it without a second to spare once it's discovered, to set at liberty the person falsely imprisoned. Habeas corpus can apply to a hospital who won't release somebody from custody, a sheriff's jailer, a military prison. All the stories we can tell about habeas corpus. Probably the greatest examples of the abuses of habeas corpus and what habeas corpus is have to do with Abraham Lincoln. Now, this case I'm telling you about right here, Abe Lincoln was, before anybody knew who he was a lawyer. He'd travel around the giant, it was either the 7th or the 8th Judicial Circuit. It was nothing but desolate county after county after county of uninhabited land, pretty much, on the open prairie and in the woods and the hills and the hollers, but a lot of it open prairie. And he spent all of his time in that district going from county seat to county seat and trying cases because there weren't many lawyers. And he'd blow into town riding his old gray mare, had his saddlebags on the back. He'd check into some inn someplace, dog tired, usually shared a bed with another man because there wasn't enough money to go around to get your own room. He'd take his breeches off and throw them up over a chair, the back of a chair in the room, go to the courthouse the next day and look for business. That's the way you find people that need you. That still happens a lot. You know, a lot of lawyers, I've met a lot, so I've done it. You go to the courthouse, people hanging around the courthouse looking for a lawyer to represent them, and they'll hit you up right in the courthouse, say, man, I'll give you $100 if you'll go in and argue this case for me. I'll give you $200 if you'll do this, that, or the t'other. I'm here on a traffic problem. Will you go in and can you do anything for me? I've met lawyers that spend all their time in courthouses trolling, as they say, trolling for clients. Nothing wrong with that. People need help. Well, that's what Abe Lincoln would do. And there was no telegraph, no telephone, no internet, so he would just make himself available by going from town to town and ranging 200 miles, maybe more, in this vast judicial district. Spent most of his time on horseback or in a buggy, but a lot of times on that mare, just plodding along, reading a book, trying to get ready for the next case. And he came into town on this slave case, the Marston case, and two of his well-known friends, a couple other lawyers, a fellow named Linder. I forget the other fellow's name. Well, a doctor named Rutherford heard about Mary Bryant and her 4 children in jail at the Coles County Courthouse. And he came to town and looking for a lawyer to file a writ of habeas corpus. He asked Lincoln, will you file this for Mary? I'll pay for it. And Lincoln said, no, I can't do it. Well, why can't you? I should say it the way they say it in that part of the world. Why can't you do it? Well, I can't do it because I've already talked to Marston. Marston wanted me to represent him, and I've received the confidences from him, and a lawyer that's received confidences and inside information from another client or another party to the case, then can't go to the other party and represent them. That's a conflict of interest and a breach of loyalty. So he didn't take the case from Judge Rutherford because Marston had already approached him. And he ended up representing the slaveholder in this habeas corpus case. Say, how did you find out about this? This is a true story. I was at the Coles County Courthouse in that big room in the middle. It's a rural courthouse, and big room in the middle that has those steel plated walls all around it and over top of it in case the courthouse catches a fire, then they won't burn up all the records of death, burial, and marriage and all the inheritance records of land. I was in that room trying to look up some documents for a case I had, and I was a fellow in there taking pictures. I had a fancy camera, and he was taking pictures of a document he had laying on a table. It was in writing, I could tell, and it was old. And I said, "What's that?" He said, "Well, this here is the court case, the judgment in the slave case where Abe Lincoln was the lawyer for the slaveholder, Marston." I said, "Let me see that." He said, "Oh, I don't want you to touch it," but he said, "You can look at it here." I took a picture of it, if I remember right, or he gave me a picture. I have it someplace. I read it. It wasn't very long. It was oh, by the way, I've got the complete text of that case in the book, Excellence of the Common Law. It's a complete text of that opinion of the court, the verdict on the habeas corpus case. I got interested in it, did some more research, knew a fellow that knew more about Abe Lincoln than any man living, and all of his family that lived around there. That's where his mother and father lived, in that county, up against Cumberland County, right on the edge. Had a farm there and had a cousin there. His name was Hall, H-A-L-L, and he farmed that farm that Abe Lincoln inherited from his mom and dad, and it was over 20 acres on that side of the fence. The only farm Abe Lincoln ever owned. And as odd as this may sound, I owned part of that farm. It was deeded over to me by this lawyer who was Abe Lincoln's secretary of, or his granddad was Abe Lincoln's Secretary of War, his great-granddad, Lewis Stanton. His name was Lewis Stanton Dodson, named after his great-grandpa, who was a scoundrel and Democrat and a brutal man, according to my friend that I did cases with. But I got that and I tried to sell some of it for $50 an inch, square inch, when I was running for Congress, and sold quite a few square inches, by the way. But it didn't amount to a pinch of nothing. I provided deeds and everything, that perfected the title of their square inch. But I still got what's left over from that. I raised quite a bit of money to help me run for Congress. Quite a bit of money. And I got famous over it. I was on talk radio in Arizona, Texas. Big talk radio. Found out about it. That's a side story. But the Marston slave case finally came down. Lincoln argued for the slaveholder and lost the case. And on the spot, in the courtroom, Mary Bryant, the slave woman, and her 4 children, it says in the decree of the court, shall be for now and forever. I believe I got the quote right. Free. Now and forever free. They were set free on the basis of the free soil doctrine of our common law. The free soil doctrine of our common law. The free soil doctrine of our common law had never been applied in the New World. You see, one of the reasons we separated from Britain was because Britain, England, Parliament said that the free soil doctrine did not apply in their American colonies. That's a quote from William Blackstone's commentaries on the laws of England. And for that reason, slavery was lawful in America according to England. See, slavery was never lawful in England, and Justice Mansfield had a habeas corpus case of a slave that came from the colony of Virginia, and he said, I'm free. And he was jailed for running away. He got rabbit in his blood and ran away, and they jailed him in England. And some kind soul filed a writ of habeas corpus in the courts of England. In the courts of England, Justice Mansfield did the research and said, I can't find that slavery has ever been lawful on this island. There have been people that have had slaves here, but our common law has never allowed slavery, outright slavery. And he ruled that way and said the slave's name was Somerset, kind of the opposite of Winterset. Oh, you don't know where Winterset is? That's a place in Iowa. That's the hometown of John Wayne. If you don't know that, you've missed out on Americana. Winterset, Iowa is where John Wayne was born, south of Des Moines, not too far south, and kind of a Quaker country down there. President Hoover was born down there in that area too. Well, Somerset was set free, and so the issue then in the Marston slave case was, and this is what the lawyers argued, the free soil doctrine of our common law. What's the free soil doctrine of our common law? The free soil doctrine of our common law says anywhere the common law applies, the soil, the land, see, we're back to land here in our common law of the land. Our common law is the law of the land. That's another name for it. The land, anybody's foot who touches land wherein our common law governs, says the free soil doctrine, anybody's foot who touches it, immediately upon his foot touching the land, all of the chains of his former servitude, if he's a slave, all of the chains forthwith fall off. That's the way they used to put it, that fall off. And you are from thenceforth and forever free, like Mary Bryant and her 4 children. Thenceforth and forever free. The chains fall to the dust and you stand up a free man or woman. That's the free soil doctrine. And the court in Coles County listened to all the arguments and said, wait a minute, this is a common law jurisdiction. It's been a common law jurisdiction since the year 1607, when the first permanent settlement of Englishmen settled in Virginia. And all that area there in Illinois was part of Virginia. And so the common, according to their charter, see, from the crown. So the common law has applied here for sure, at least at that far back. Why is it we're allowing slavery? If the foot of Mary Bryant crosses over from Kentucky into Illinois and her foot sets on the ground after she takes that ferry across the river down there by Cave and Rock, that ferry's still there, by the way. Well, then at that point, she is not just free while she's in that state. She is thenceforth and forever free. Her chains have permanently fallen off. Now you can see that would create a problem with the folk in Kentucky. But not much. Remember, during that horrible war between the northern and the southern tiers of the states, at any given time during that war, at least 20,000 Kentuckians were carrying arms in the Union Army, at least 20,000. Kentucky was split to horrible, as was Tennessee, east and west. You could argue that most Tennesseans supported the Union. Most. They didn't have a dog in the fight. They weren't from the deep south. For a lot of reasons, not to mention economic, of course. Well, we're going to talk more about the Marston slave case and a few other slave cases, habeas corpus, Abraham Lincoln, God help us. Help me remember, Miss Francine, to talk about that next time. Habeas corpus is too big. The history of habeas corpus, I hope I remember to talk about that. It hasn't been around forever. We had other ways we tried to avert false imprisonment. Why is false imprisonment important? Because it's contrary to the fundamental tenets of the trust settlement of God as expressed throughout the Bible. Be fruitful, multiply, and scatter over the faces of the earth. If man imprisons people falsely, if we imprison anybody falsely, we have flown in the face of God and interfered in the fundamental right of every person to scatter over the land. And that's why false imprisonment is part of our common law tradition. This is Brent Allen Winters. This is In Church. We're talking about the laws of nature. The laws of nature, our common law tradition. A specific slice, our Constitution of the United States. And Miss Francine, Lord willing, will play us a song. We'll come back and talk about the laws of nature's God. Lex Scripta. This is Brent. Brent Allen Winters, commonlawyer.com, www.commonlawyer.com, coming at you from the remote hinterlands of the Wabash River Valley, where the hogs, the frogs, and the dogs keep up a racket all night long.